Hello, I'm Ruth George, and this is the Good Life and Legacy podcast, where we explore answers to the question, how are you creating a great legacy by living well, planning well, and supporting those that you care about? And today I have an extremely special guest, the Honorable C. Raymond Radigan. Judge Radigan served as judge of the Nassau County Surrogates Court for 20 years, where he also served as chief clerk and deputy chief clerk. He has been a driving force in the revision and update of trusts and estates law and practice in New York State. Judge Radigan was a special or adjunct professor at various law schools and has lectured extensively at numerous professional, business, and social service organizations. Judge Radigan is a member of the American Bar Association, New York State Bar Association, Nassau County Bar Association, and its Decedent Estate Committee, Long Island Lawyers Association, National College of Probate Judges, and New York State Bar Association Judicial Section, where he served as president of the Judicial Council and as a former delegate to the House of Delegates. He is also a former chair of the Executive Committee of the Surrogates Association, chair of the Advisory Committee to the Legislature on EPTL and SCPA, and former chair of the committee to examine the effectiveness of the fiduciary appointment rule. Judge Radigan is a fellow of the American College of Trust and Estate Counsel, member of Federal and New York Bar, Knight of Malta, a former president of the Society of the Friendly Sons of St. Patrick, a member of the New York State Guard, where he served as colonel, and editor of several trust and estate publications. He is also a certified arbitrator and mediator by the American Arbitration Association. Judge Radigan publications include co-author of New York Estate Administration, Surrogates Forms with Commentary for Computer Use, and Warren Heaton's Surrogates Courts. Of course, I could go on and on, but suffice it to say that Judge Radigan is simply amazing, and I thank you so much for being here, Judge Radigan. Welcome.
Thank you very much. I'm glad to be here, and you can pose any questions to me. I'd be happy to answer them. And I hope I can be of assistance to your audience.
Wonderful. Right. So prior to this, I asked you a series of questions, and you were kind enough to give me your incredible answers, which I've been posting on social media. And so to be helpful to the public, I thought I would just go through some of those questions and just hear your thoughts about surrogates court and some matters in general in regard to what happens in surrogates court.
Okay, fine.
Okay, so why don't we start? Just give us a basic review of what surrogates court is for.
Okay, in the state of New York, we have the Surrogates Court, which is a court that was in 1962 was formulated constitutionally. Before, we were a court that was created by the legislature, but the people of the state of New York created the court in 1962. So we're a full court of record. Unlike some other states where the surrogate is just an administrative judge, the surrogate in New York is a full-fledged judge. We conduct jury trials. We can do all sorts of proceedings, probative wills, people who die without wills, we handle their estates. We handle guardianship of minors. We handle guardianship of disabled individuals. We have concurrent jurisdiction with the Supreme Court over inter vivos trusts, that's living trusts. We have concurrent jurisdiction with the Supreme Court over a lot of other proceedings, such as Article 81 proceedings in certain instances where we handle guardianship for people who are unable to handle their affairs for themselves. They get dementia or some other type of disability. In the state of New York, we have 62 counties, and there's a surrogate in each county, except for the city of New York, where we have two surrogates, one extra one in New York County, Manhattan, and one extra in Kings County, which is Brooklyn. But by and large, we do have 62 surrogates courts throughout the state. And in the city of New York, Nassau, Suffolk, and Westchester, and three upstate counties, which is Buffalo and Rochester and Syracuse, they're full-time surrogates. That's all they do is surrogate work. In the other counties, some counties, they don't have, in Nassau County, we have a population of about 1,400,000, 1,500,000. And in some counties, they don't have as many people. In fact, we have more people dying than they have living in Nassau County. So those surrogates are what we call triple hatters. They're elected as surrogate, but they are also assigned additional work. So they can be family court judges, the county court judges, as well as surrogate, or Supreme Court judges, depending on what assignments are given to them. And again, our jurisdiction is over any and all affairs dealing with the estates of decedents. So that's wills. That would be people who die without wills. It would include handling of the estates of people who are beneficiaries of those estates. So if anyone's under a disability, such as mine is, we have jurisdiction over guardianship. And if somebody is under other disability, such as an aged person who suffers a disability, gets dementia or something, we have jurisdiction over that. In addition, we have concurrent jurisdiction with other courts dealing with adoption. And in some counties, the surrogate does all the adoptions. And that's what I used to do in Nassau County. We did all of the adoptions. So our jurisdiction is quite extensive. When attorneys put together estate planning, they take into consideration a lot of things over which we have jurisdiction. It's not only wills, it could be living trusts, it could be health proxies, it could be living wills where you leave behind directions for the doctor and for people that you have trust in, who can make decisions for you about maintaining you, sustaining life, whether to provide hydration, nutrition for you, all of that, the surrogates have jurisdiction. So that's a broad overview of what the surrogates do. In other states, we have probate courts, or it's called something else. It could be called something else. Some of those judges of those court have the same type of jurisdiction as Nassau County, but some, such as New Jersey, those judges are really administrative judge. And if there's going to be a contest, you would have to farm it out to another court to try. But in New York, we have full jurisdiction over anything dealing with the affairs of a decedent.
What a wonderful review. Thank you so very much. And interesting to hear some of the other areas of the state as opposed to just where I'm at right now. So that was wonderful. Thank you. As far as wills go, can you tell us why the court is interested in finding a will being valid and as the person who passed as their last will and testament?
Yes, in New York in particular, we're very strict about the formalities of wills. A testator, that's what we call the person who executes a will, A testator, be it a male or female, we used to call them testators and testatrix. Today, we try to say as neutral as possible, so we call everybody testators. A testator leaves behind a will indicating what they want done with their estates. Now, you have to remember that this is a right and a privilege given to people to execute wills. If you don't execute a will and you are not survived by certain relatives, such as in New York, if your closest relative is a second cousin and you die without a will, your estate is going to go back to the state of New York. You see, under early ecclesiastical law, and that's where our laws really derive from, we follow the English law, which is the common law, as opposed to the continental law, which is different laws altogether. They have things such as forced heirship, where you have to leave something to individuals. In New York, and in most of our common law jurisdictions, which are United States, most of us are common law jurisdictions. We are not civil, like California would be civil, follow the civil law, okay? We follow the common law, and most of the states do follow that. So the state of New York gives individuals the privilege of leaving wills. And we do have strict formalities about executing wills. But the beauty of it is once your will is probated, and I'll get into that in a moment, but once your will is probated, we may not see you again. We don't watch over your estate. We leave it to the person that you select, who's called an executor of an estate, to handle your estate. And you only come back to us if there's a need, such as there's a dispute regarding a clause in a will, you need a construction, there's questions about attorney's fees or commissions or whatever it may be, you may have to come back. But in Nassau County, I would probate, let's say, 3,800 wills. I'd only have 100 where there'd be contests or reasons for people to come back. So in most instances, once the will is admitted to probate and letters issued to a fiduciary, the fiduciary gets on with administrating the estate, and the people are happy with the administration. Everybody cooperates with each other, and the estate gets on with the administration. So to answer your question, why is New York and the surrogate so concerned about the will? Well, the decedent is dead. So there's somebody who has to be there to protect the interests of the fiduciary, to see to it that their wills being the instrument and their wills being what their intent is, to see to it that that's fulfilled. So the surrogate is the substitute for the decedent, and we want to make sure that their wishes are fulfilled.
Right. And so it's very important that formalities be followed, and that in your court papers, when you're presenting your petition to the court, you have all of the necessary papers in there. And I know sometimes when I'm dealing with my clients, they don't understand why we're doing X, Y, or Z, but it's just because we have to show the court any number of things depending on the circumstances at the time. And it's for a certain reason. We have to follow the statute, we have to follow the formalities, and we have to provide the court with everything necessary so that we can get that authority for our fiduciary. So what happens when a person wants to contest a will? Can you talk to us a little bit about what would happen in a potential will contest?
Okay, well, as far as a will is concerned, we have to have a testator who is over the age of 18 and who's competent. Competency means that they have capacity. You don't have to be Phi Beta Kappa. You don't even have to have as much capacity to enter into a contract, to enter into a will. Why? Because when you're entering into a contract with somebody, you're negotiating with someone else. When you're executing a will, you're dealing with yourself. So therefore, you need less capacity to execute a will. You have to know what you're doing. You have to know roughly what you're doing. You're executing a will. You have to know roughly the natural objects of your bounty. Usually, do I have a wife? Do I have a husband? Do I have kids? Do I have grandkids? Know your family environment and know roughly, not down to the exact penny, know roughly the size of your estate, where your assets are. Do I own real property? Do I own stocks and bonds and bank accounts, etc.? So to have capacity, I have to know that I'm executing a will. I am able to bring to mind that I am executing the will. I can bring to mind who the natural objects of the bounty are. I can bring to mind roughly the size of my estate. If I have that, then I have capacity. In addition to capacity, I have to make sure that the instrument that I'm executing is validly executed. So a will has to be in writing. It has to be witnessed by two individuals. I have to declare the will to be my will to these two witnesses, and they have to sign. Usually, in addition, we have an affidavit where they set forth exactly what took place, that this ceremony took place, that I asked them to be the witness to my will. They consented. I signed, they signed, the will was supervised by the execution, by the supervision of an attorney. And all of that is set forth in the affidavit so that we can prove to probate. Probate means to prove a will. So when somebody dies, the nominated fiduciary usually is known. The decedent would have told this individual who's going to be the fiduciary, or the people find the will among the effects of a decedent in a little tin box at home. Or they'll go to the attorney that they know is the family attorney, and very often that attorney will hold on to the original will, and somehow somebody will get their hands on the will. It's usually the attorney, because he or she will keep the original will and give only a copy to the decedent. You see, it's very important for us to know where the original is. And that's why the attorney very often keeps the original. He'll give a copy to the client. Don't execute multiple wills. Only have one will that you execute. And usually it's the attorney who keeps it. There are several things you can do with a will when you execute it. You can give it to the attorney, and in New York, a lot of attorneys do keep the will, and they keep it in their vaults at the office. Or the attorney can give the original to the client, and the client can do several things with it. Put it in their little tin box at home, or put it in a safe deposit box. Now, putting in a safe deposit box may cause delay, because we're going to have to go to the court, get an order to open up the box, to get the box. So it'd be better if you don't have it in a vault, in a bank vault. You can give it to your nominated executor, the will, or you can file it in the surrogate's court. Some people do that, but some people don't. The reason why we got to be careful about wills being on file is if you put a will on file in the surrogate's court for safekeeping, that's not a file that's filed with the surrogate's court. However, the clerk of the court is going to go and look to see if wills are on file. And if they are, they're going to take it and put it in the probate file. Why is this complicate matters? Once we have a will on file, we have to notify all those people who are in those instruments. So if I have 10 wills that I've constantly filed with the surrogate's court, and the clerk takes those files and puts it in the probate department, I could have 10 different wills with 10 different plans, and all of those people are going to have to be made parties to the proceedings. Now, in New York and states that follow New York law, the only people that we have to notify when we offer a will for probate is the distributees, those who would take if there was no will. Under New York, this is followed under State Powers and Trust Law 4-1.1. We have the wife and the kids and the grandkids and the parents and so forth, and cousins, aunts and uncles, but we stop at second cousins. If your closest relative is a second cousin, then it goes, and you have no other relatives and you don't have a will, it's going to go back to the Crown substitute, the state of New York. New York is going to get everything, okay? So get back to your question about the wills and the procedures. What happens is somehow we get our hands on the will, and the will has to be offered for probate to prove the will. And what happens is you have to find the will. And I already told you where the will could be. It could be with the attorney. It could be with the decedent, either in a little tin box. It could be in a bank account. It could be the executor, or it could be on file in the surrogate's court. So somehow you get it, okay? And you go to the lawyer, and the lawyer prepares a petition to probate the will. And he will do his best. And this is what usually happens. Usually, as I indicated, I probated about 3,800 wills a year. And most of the family, they get together. Judge Bennett, my predecessor, used to tell the story, which is a true one, that a decedent would die over the weekend, and the family would get together and make the funeral arrangements, and they'd get with the lawyer. The lawyer would sit down with all the family members and get the petition prepared to probate the will, get all the consents from all those people who have to be necessary parties. And the attorney would go on Monday to the surrogate's court. We'd probate the will that day. We'd issue letters. The executor would go to the bank and withdraw funds and distribute funds to the kids, and they'd buy Cadillac cars. And by Wednesday, when the funeral would take place, they would go to the funeral in style in their Cadillac cars. Now, this is a true story. We used to be able to handle estates expeditiously. And if everybody cooperates, then that's fine. Now, if there's going to be a contest, then there's going to be a problem. Somebody is going to be upset because they're not happy with the will. Now, of course, if you have a happy family and you provided for everyone, if you give everything to the wife, the kids are of the same marriage, they're going to be happy. Mom gets it, and then mom is going to give it to the kids, so they're going to be happy. Everything is fine. But with today's society, when we have multiple marriages and multiple kids from multiple parenting, then there can be contests. But again, fortunately, again, I get back to my story of Nassau County, 3,800 wills. Most of them go through, no problems. It's only about 100 of them that we're going to have some problems.
Mhm.
We're going to have problems either because there's going to be a contest because somebody's unhappy, or there's somebody under disability who can't give us a consent. You see, when a will is offered for probate, everybody who's happy can give what we call a waiver and consent. They waive the service of citation. Citation is the equivalent of a summons. We don't have summons and complaints in the surrogates court. We have petitions, and the equivalent of a summons and complaint. The complaint would be a petition. The summons would be a citation. So a citation would have to be served on individuals who won't cooperate and give a waiver and consent. But again, most instances, we get the waivers and consent, and we can offer the will for probate. However, if there's somebody who's not happy with a will, or somebody's under disability, we have to serve those people with citations. And the citation has a return date. And there's certain formalities about all of that, which we don't have to get into. What you're mainly concerned about, there's going to be a return date. And on the return date, you go to court. The return date is going to be in the citation. It's going to tell you to come to court. Now, of course, an infant or somebody who's under disability is not going to come to court, usually. So on the return date, the court will see that this person is under a disability. They're not here. They're defaulting. So therefore, if somebody doesn't appear on their behalf, if somebody is incompetent and they have a guardian under Article 81 of the Mental Hygiene Law of New York, that guardian can come in and appear for the individual. Or if an infant is under the age of 21, under the age of 18, and has a guardian appointed for that individual, that guardian can come in and appear for the infant. But very often we don't have guardians for these people who are under disability. So the court is going to have to appoint a guardian ad litem. That's an attorney who the court will appoint to represent the interests of the people under disability. So when there's going to be a contest, a citation will issue, the parties will come to court, and usually before filing objections, people will want to know something about the execution of the will. They want to know whether it was duly executed, whether the decedent had testamentary capacity, whether or not there was any fraud or undue influence. So the first thing they want to do is they can ask for an examination of the attesting witnesses. That's why it would be very smart for attorneys to be attesting witnesses. Now, some attorneys say, well, I don't want to be a attesting witness because I'm going to be a witness to the will, and I'm going to be disqualified and I can't handle the estate. Well, you're going to be a witness in any event, because you supervise the will. Laws under the state of New York require you to be a witness if the person wants to examine you. So you're going to be disqualified anyway. So you might as well be the person who puts the plan together. You'll only be disqualified. You can still handle the estate. You'll only be disqualified from handling the contest, the will contest itself. So you might as well be one of the attesting witnesses, because you have all the knowledge. You'll be able to answer the questions properly. And it's very unwise to get a next door neighbor to come in and be a witness. they're not prepared to answer all of these questions, okay? So you should be one of the attesting witness, and you should have another attorney or a paralegal or somebody who is able to handle the questions when they're posed to them during the course of the examination. Now, we have, under the laws of the state of New York, what we call Terrorem clauses. Sometimes people will provide a bequest to somebody, but say, if you challenge it, you want more than what I'm willing to give you, then you get nothing, okay, if you contest the will. We allow you to come in and do a 1404, and you will not trigger that Terrorem clause. So you'll at least get the information so that you can make up your mind knowingly whether to challenge the will or not to challenge the will. And that will not trigger the Terrorem clause, okay? So now you make up your mind. The court will assign a date for the witnesses to come in. Those examinations, ordinarily, pursuant to court rules, have to be held at the courthouse. The reason for that is that the judge or a law assistant is available to make rulings during the course of the examination, okay? So those examinations will take place at the courthouse. And when you're finished, you'll make up your mind whether or not you want to contest on the grounds of either the decedent didn't have capacity, or it wasn't duly executed, or there was either fraud or undue influence. So you're going to have to make up your mind, okay? If there's an Terrorem clause, there's a gamble, whether or not you want to interpose the objections. If there is none, then you're fine. You can file your objections, and if you win, fine. If you lose, then you'll still get your bequest if there's no Terrorem clause, okay? Now, the usual objections are that the will wasn't duly executed, that there was no capacity, that there was either fraud or undue influence. The burden of proof on the issue of due execution and testamentary capacity is on the one who's offering the will for probate. We call that person a proponent. That's usually the executor or the family member who's offering the will for probate. Any allegation of fraud or undue influence, the burden is on the one who's alleging that, the objectant. We don't call them objectants usually, we call them contestants. They are contesting a will. So they have the burden of proof on that issue, okay? Now, in New York, we have rules regarding evidence. And one of the most important things that a practitioner has to know, which is they usually don't have to know in other jurisdictions, but in New York, in the surrogates court, what you have to know is CPLR 4519, called the dead man statute. That means that anybody who has an interest in the outcome, a pecuniary interest in the outcome of the proceeding, such as a will contest, because the decedent's lips are barred and they can't tell the story, your lips are barred. So anybody who wants to probate the will or anybody who wants to contest the will cannot tell us what they say, a conversation that they had or communication that they had with the decedent. They are barred. They can't offer it. It has to be third parties. And the attorney fiduciary who did all the estate planning, and hopefully he's not a beneficiary under the will, he will be able to testify, as will the learned other attesting witness who hopefully is another attorney who participated or a paralegal who participated in the overall estate planning. So if you have a will contest After you complete the 1404 examinations of the attesting witnesses, you make up your mind whether or not you're going to probate a will, contest the probate of the will. If you don't contest it, then the court has already set a time for you to file objections. So usually the court will say 1404 examinations are to take place, and objections, if any, are to be filed within 10 days after the completion of the 1404 examination. So the 1404 is completed. You have 10 days to file your objections. If you file it, fine. Then we get on with the contest, which I'll get into in a minute. If there's no contest and no objections are filed, then the attorney for the estate will offer the will for probate. He will ask the court to sign a decree. He'll submit a decree. The decree will be signed. The will be admitted to probate, and an executor will be appointed. The executor will get letters. They'll get on with the administration of the estate. If there's a contest, if objections are filed, then usually now the individual will want to do other examinations. They want to examine other people who may give them information regarding the objections that they interposed concerning whether the will was duly executed, whether the decedent had capacity, whether or not there was fraud, or whether or not there was any undue influence. And the proponent has also that same opportunity to, in other words, to get depositions of individuals to fortify the will, such as examining doctors, treating physicians, getting hospital records, any information that's going to help you either to prove the will or to contest the will. Okay, that's the
overview. I could listen to you forever. I love all of your information. It's just wonderful for everybody to hear, including myself. So do you want to continue on? Because you're right at the moment of, we're in the world of objections being filed, and now what do the parties want to do, either the proponent or the objectant, as far as looking to other people and other potential records, and that phase at that point. If you want to take us then forward and see what.
Okay, let's first take the proponent. The proponent wants to probate the will, okay? And hopefully you have two good witnesses who will be able to prove your will, okay? They will be able, during the 1404 examination, when we, at the 1404 examinations, there are three people who can be potential witnesses: the two witnesses and the attorney draftsman. Now, if the attorney draftsman is also one of the attesting witnesses, then those two people are one. So you only have two witnesses. The attorney draftsman witness, who's all one, and the other witness. If you have three individuals, then you're going to have to examine all three. If there is an Terrorem clause, then you have five potential witnesses. Not only the two witnesses and the attorney draftsman, but also the proponent of the will and also the nominated executor of the will. Okay, so that's five people. Again, it's possible that four of those people are going to be one. The attorney draftsman may also be the witness, may also be the proponent, may also be the nominated executor. So that individual will hold the four positions, okay? If not, you're going to have four different individuals plus the other attesting witness. So the proponent wants to do the examination of those individuals, or reach out to those people to make sure that they're on board, and you bring them in and get information from them. And you want to get hospital records. You're the proponent to show that the decedent was competent at the time when the will was executed. Remember again that all you have to have is enough capacity to bring to mind those three things that I told you about, that you're executing a will, you know the objects of your bounty, you know roughly the size of your estate. And you want to be sure that the decedent is able to have that ability. And even if you're a lunatic, even if you are someone who has been declared an incompetent, if you have a lucid moment and you're able to prove that you had a lucid moment at this particular time to bring to bear the fact that you're executing a will, that you know the objects of your bounty, you know the size of your estate, if you can do that, and you have witnesses who can able to demonstrate that, and if you have hospital records to show that you had a lucid moment, that is going to help you in being able to prove your case. Now, you may also be able to get neighbors and relatives and other people who aren't beneficiaries, who are not going to be barred by the dead man statute, to be able to prove your case. So you want to prove your case. You, the proponent, are the one who's going to, even with a jury trial, you have the right to open and close because you have the burden of proof. You have the first burden of proof on the issues. So therefore, you're going to present your case. The contestant, on the other hand, wants to prove that the will was not duly executed, that the decedent did not have capacity, the decedent didn't know the size of the estate, there was fraud, there was undue influence. And they're going to have to get enough witnesses to be able to establish that that these things existed. Now, the contestant has the burden of proof on showing fraud and undue influence. We don't have too much fraud in will contests. Fraud would be something like somebody putting an instrument before you and you thought it was something else. You didn't know it was a will. You thought it was a deed or some other type of an instrument. You didn't know it was a will. We don't have too much of that, but we do have undue influence. Mm-hmm. And then undue influence comes into play in several instances. Once where we have a confidential relationship. That's where somebody is taking advantage of an individual. And who could that be? It could be an attorney who gets themselves in as a beneficiary under the will. We call them Putnam situations. That's a case where an attorney, a matter of Putnam, where an attorney ended up being a beneficiary in a will. Or he utilized his influence in order to get himself nominated as fiduciary so that he could get the legal fees and also get commissions. Or just being a family member, you being named as a beneficiary, or you being named as the executor of the estate, that alone, that relationship alone is not enough. But if it can be proved under certain situations, take this, for example, we have a decedent who has 3 children. 2 of them are far away, living in other jurisdictions, other states. And you have another child who's a next door neighbor or lives down the block or maybe even lives with the decedent. You do have the family relationship, but maybe it's more than that. Maybe this individual does all the banking for the decedent. The decedent doesn't do the banking on their own. It may very well be that for convenience purposes, the mother will open up a bank account with the daughter who lives with her or lives down the block from her, only for convenience. And if the daughter is willing to throw everything back in the pot and have everything distributed among the children, fine. But if it's a joint bank account and she claims it's a true joint bank account, and there's a presumption under our banking law that it is a true joint bank account, so she takes all that's in that account on the death of the mother, and she's not willing to throw it back into the pot, and we can show that there was a confidential relationship, or if the mother chooses this person in a confidential relationship to be a beneficiary, and this person has a power of attorney or is the one who selects the attorney who does the drafting, if this normal family relationship goes further where there's a confidential relationship and the individual is in a position to unduly influence. Influence is okay. It's undue influence. If they unduly influence an individual to do what they want rather than what the decedent wants, then we got problems. And if the contestant is able to establish that, then they will be able to show that there was undue influence. So what the contestant is trying to do is to show that the decedent never had the capacity to execute a will and get proof, however they can regarding that they show that the decedent didn't know what the assets was. You can able to demonstrate that they never handled their financial affairs. Somebody else handled their financial affairs, and they never were able to bring to mind really how much they owned. I had a situation where a woman was very wealthy, and she didn't realize how wealthy she was. She knew roughly that she owned a couple of apartments, and when we asked her what she thought the value was, she said, a couple of hundred. Well, it was a couple of $1 million worth of property. So she wasn't able, and the attorneys were smart. They knew that she didn't have capacity to bring to mind what the true assets were of the estate. And therefore, he decided that this woman needed help and went on with Article 81 proceedings rather than execute a will for her. So the attorney has to remember that he's representing the testator, the person who's putting the plan together. And while family members can help in putting information together, the attorney must always remember that the client is the testator, the one who he's doing the estate planning for. And he wants to make sure that it is his or her wishes that are being fulfilled rather than some other person, a relative, a daughter, a son, or whoever it may be. And that attorney must sit down and get his communication with that individual who he or she is representing. And you can get help from family members, but always remember that you have to be sure that this is representing the intent of the client that you're representing, who is the testator or the person who you're doing the estate planning for.
Mm. Well, as you're speaking, I'm thinking of so many things in regard to estate planning and how people have to put themselves in the best positions possible as far as planning in advance and taking protective measures sometimes, when people think that they can leave things to last minute, and then last minute means we've got all sorts of circumstances that could potentially lead to a will contest. It all sort of wraps into each other as far as looking at estate planning and probate and how we all need to be more proactive on the estate planning end. But very interesting. All right. As far as a general range with contests, I know I'd asked you this question previously, and just tell us some of your thoughts on how long a potential will contest could take, even if it's just a range.
Well, will contests sometimes after the depositions are taken, people realize that they don't have a contest. They really can't prove. When the attorney for the contestant sits down with the client and evaluates everything, the attorney, who's a good attorney, is going to say, look, we just can't prove the allegations here. So I suggested you don't object. And very often we get attorneys who say, look, I looked into this, and they have a solid case, so you can't contest it. But there are other cases where the attorney says, look, I think we should go forward with this. There is enough evidence here for us to proceed. Now, you're going to have to make up your mind whether or not you want a jury trial or not. The surrogate ordinarily is someone who is a trust and estate lawyer or who came through the ranks of the surrogate's court and has knowledge of surrogate matters. So you want to know whether or not you want to try the case before the judge, or you want it before a jury. Now, if you really want a jury trial, some people make a terrible mistake. Everybody who wants a jury trial has to demand a jury trial. And why this is, and there's a filing fee for that. Okay. Now, sometimes people say, well, I'm going to wait and see if the proponent is going to file a demand for a jury trial. Let them go pay for it. They have the money. They have the estate assets. Let them file it. Well, they get fooled sometimes because the proponent purposely will ask for a jury trial and the other side doesn't, and their time to ask for a jury trial expires. And then the proponent says, I don't want a jury trial. They purposely ask for the jury trial to throw you off guard so that you don't ask for a jury trial. Then they withdraw it because they wanted the trial before the surrogate anyway. They didn't want a jury trial. So you got to be careful. If you want a jury trial, you better ask for it, okay? Now, that's a decision that you have to make, okay? Whether or not you want 6 people. There were 6 jurors who preside over a jury trial, not 12, like a criminal matter. Mm-hmm. So 6 jurors. Who knows what they're going to think, okay? And depending on whether you're the proponent or the contestant, you got to think ahead. Let's say you're the proponent and you have 6 kids and you only leave money to 1 kid. Well, ordinarily, a jury is going to say, why would you give to 1 kid? I would never give to 1 kid. You give it equally, okay? So right away, you're going to say to yourself, as a proponent, why would I want a juror? And all I need is 2 jurors to say no. And then the will, you can have a hung jury, okay? Why do I need that? So, and the same thing for a contestant, okay? If everything was done equally and you say, no, under a prior will, the decedent gave me everything, And then there's a question as to whether or not you unduly influence. All of this is going to be important if you're going to contest the file, a matter, whether or not you want the judge or you want the jury. So give it a lot of consideration. And experienced lawyers will know whether to do a jury trial or not do a jury trial. That's going to take a lot of experience. Now, you asked the question, how long will it take? Well, it all depends. You can try a case. The judge doesn't want to preside over discovery proceedings. They want to make sure you're ready. Mm-hmm. So when you make up your mind that you're now ready for trial, you file a note of issue and statement of readiness. Now, you better be sure that you're ready for trial and the other side is ready for trial. It's better if the two sides get together and agree, yes, we're ready for trial. We can't settle this matter. Let's get on with the trial itself, okay? And we agree, okay? If there's any dispute, the court, when you file a note of issue and statement of readiness, the court is going to call you in for a conference, which the court will preside over or will have a law assistant preside over. And the first thing that they want to know is, are you really ready for trial? And if you're not, then they will schedule any outstanding issues that you have to get resolved by way of depositions or subpoenaing documents and the rest of it. When you file your note of issue, we want to know you're ready for trial. And we will, if we feel that you're ready for trial, we will sit down with you and we will even allocate time. So let's say you want to take a witness out of turn, because let's say it's a doctor and you don't want a doctor sitting in a hallway for 3 days or 4 days. We get an agreement about taking this particular witness out of turn. We get agreement about exhibits in advance, so that we don't have any long contest or disagreement regarding what's going to be admissible. So we'll know which exhibits are going to be admitted and which are going to be contested. So we'll have that all in advance, and each one will have their arguments ready for the judge when the time comes for offering something into evidence. Everybody will be prepared to make their arguments. So when the judge or law assistant is convinced that you're ready for trial, we will set a date for trial. Now, in the surrogates court, we're very strict about that date. When we give you a date, we're giving up something else, which we could try. So we want you to be ready you better be ready on that date, okay? And if you're coming in and you say you're otherwise engaged, well, you shouldn't be otherwise engaged. You already knew you had this date, and you shouldn't be otherwise engaged. And even if you say you're otherwise engaged, don't be surprised if the surrogate takes a recess and calls the other judge to find out if you're engaged or not. And if you're not otherwise engaged, you're in deep trouble, okay? So be prepared for the trial. If it's a jury trial, it's going to take longer, because with a trial by the judge, we can do it sporadically. It doesn't have to be continuous. Okay, we can take a little bit and then accommodate a witness and come back a different day, and the judge can get on with other work. It's a lot easier. With a jury trial, it got to go on, right? Continuously. Okay. So you have to take that into consideration. I had a jury trial that lasted over 2 months. It can happen, okay? It was continuous. We went on, but the estate was it was $1 billion estate, and there was a lot to fight about, and they fought. Okay, and but we worked full day, 9 to 5. Okay, And it just went on and on and on, and there's nothing you can do about it. The average non-jury trial would take maybe a day or two, okay? A jury trial may take 3 days, okay? Can take shorter, can take longer, as I told you. Can have several months go on. But it all depends on the size of the estate and the number of witnesses and the complexity of the problem.
So in the phase of taking depositions potentially and acquiring documents, how long in general would you say that phase may be?
In the city of New York, Nassau, Suffolk, and Westchester, and the 3 upstate counties, we have law assistants. And fortunately, we're able to make sure that people are kept up to date. Once a matter is before us, we watch it, and we schedule depositions, and we make sure that things are on track, and things are smoothly followed. With the upstate surrogates, some surrogates can have the time to do the supervision, but if they're otherwise engaged because of all the other work that's assigned to them, they may not be able to do this. But with the larger courts, with the larger law departments, we are able to accommodate.
And then that brings in, I think, when the objectant thinks there is potential other non-probate assets, there's a whole nother proceeding for that, but they're unaware that those non-probate assets are not a part of this will contest, but they may be assuming they are. Those types of thoughts.
Well, many things can happen with that. There's a question as to whether or not these, what we call non-testamentary assets, should be estate assets, should be testamentary assets, such as a joint bank account, whether or not, as I indicated before, whether or not it was a true bank account with right of survivorship, or whether or not it was set up for convenience purposes, because 2 kids were living far away and one kid was nearby, and the mother set up the account for convenience purposes so that the daughter could make deposits, withdrawals, and help her in financial affairs. Well, that's really a convenience account. That's supposed to come back into the pot for distribution. But there can be all sorts of problems. Today, with estate planning, it's not only a question of will. The lawyer has to sit down and look at various other aspects of estate planning, such as joint bank accounts, Totten Trust. Totten Trust is a bank account in trust for a beneficiary. You could have living wills. Living wills can be revocable or irrevocable, okay? Revocable means I can change it. Irrevocable means it's permanent, okay? And that avoids probate. A living will, upon your death, the trust can continue, or you can provide under the trust that there be actual distribution to family members right away. All depends on what your estate planning is. In estate planning, you will need consideration of health proxies, living wills, instructions to people what to do with your life, and in the event that you become comatose, whether or not you want to be sustained with life support, etc. So there's a lot more to estate planning than there was years ago. Years ago, all a person would do is go for a will, and that would be it. Today, it's so much broader. The attorney has to analyze all of the assets that you have, how they're held. You may have business entities. You may have stock in business entities. Whether or not there's buy-sell agreements, whether or not there's shareholders agreements, all of that has to be attended to. So there's so much that the attorney has to sit down and work out with the client. Let me tell you a problem that the courts are having right now. Because of the pandemic, a lot of matters had to be adjourned because people just couldn't appear in court, and we had to do Zoom meetings and the rest of it. And in addition to that, we have a fiscal problem where the courts, when I was a surrogate in Nassau County, I had a much larger staff than what the surrogate has. She has 1/3 of what I have, what I had. And as a result, you don't have all the law assistants. I had 9. Okay, she has 3 or 4. We can't do all the sessions that we used to be able to sit down and work out settlements with people. So the courts or the parties have to resort to mediation, where we sit down and do all the things that we try to do, what a judge tries to do in settling a matter. And there are practice and procedures. Either the attorneys see what the problem is, and they go to a private individual to do the mediation, or the court assigns a mediator. And very often they come to people like myself, a retired surrogate, to do the mediation. And that's what I'm going to have to start now.
Oh, so you're so generous with your time. Thank you so much. Okay. I just appreciate it so much. You are so generous. And thank you, thank you, thank you.